Hello, welcome to another episode of the Unisoft Question. And today I'm interviewing Jordan Goldblatt, managing partner, Adair Goldblatt Bieber LLP Toronto. Hello, Jordan. How are you?
I'm good for that. How are you doing today?
I'm great. You're one managing partner in a long line now of managing partners of leading Toronto firms that I have interviewed. So I'm really excited to have you on the show.
Well, I'm glad to be here. I like that the reference is to a leading firm. I appreciate that. Um, so I'm excited to be here and answer questions as honestly as I can within the confines of my partnership confidentiality agreement and remaining licensed by the Law Society.
Okay, it's a very thinly veiled humor, I assume. But let's
Again,
take it seriously.
yes.
Okay, let's take it seriously. Okay, now it's really interesting. I looked at your background, and there are so many things I want to talk to you that are substantive. So I don't want to do a really deep dive into your bio. I just want to run over it, sort of. And I know that you went to McGill for a bachelor's, like so many guests of this show. You had a bachelor's in a field that is kind of sounds a little generic to me. North American Studies. Explain.
Well, I think it's the
Did you
definition
do it
of
for grades?
so what North American Studies is it's an attempt to be a liberal arts education, similar to what you might see in the United States. So it
Mhm.
focuses on history, economics, political science, and history, economics, political science, and English across the United States, Canada, Mexico. And I think as my family thought of it when I applied, it's really just becoming really good at Jeopardy. It's really focusing on categories that will help you in that game show if that's where your career ends up taking you. But that's what it was.
Speaking of your family and the direction that took you to the legal profession, is there another Goldblatt that's a little bit more famous than you, maybe?
I think, including my siblings, there's probably other Goldblatts who are much more famous than I am. But yes, I think what you're talking about is my father is a lawyer as well. He is a founding partner at what is now Goldblatt Partners. And what I often think about is long term, the goal should be for every firm to have Goldblatt in the firm name. It's just a good name. You know, there's an old Saturday Night Live skit where John Bon Jovi is putting together that band. He says, "Look, Bon Jovi's just a good name. It has nothing to do with me." But yes, my father is the Howard Goldblatt of Goldblatt Partners.
This is why I invited you to this show. I knew this would happen, so this is the best. Well, what was it like working for your dad? Did you work for him or did you work with him? Let's set the
I
record.
well, I would say work, not even really work with. So I started at Leinster Slat and was there for a number of years, and then um, moved to what was then SAC Goldblatt Mitchell. And really, when I went there to SAC Goldblatt Mitchell, it was to build out their civil litigation practice, which was always where I was. So my father was practicing and continues to practice in the labor world. He does some public law work as well. But um, I think about all the lawyers who I've had the fortune of working with in my career, and my father is not one of them. We have never been on a case together. He's done cases with some of my partners here, but we've never actually worked together. We were partners in a law firm together, uh, but I only saw him either as a father or as a partner. That's the extent of our, our relationship, which is actually pretty good as I reflect on it.
He must have influenced you in some way. I mean, can you talk about that a little bit?
Yeah, so we have a really good relationship, a really special relationship, and he influenced me in the way that I want to practice law, and to be more specific. Um, Growing up, I have a very distinct memory of him running from our house to catch a bus to go to work with two huge briefcases in either hand. And I also equally remember him showing up at, school recitals and whatnot, again, with those two huge briefcases in his hand coming directly from work. And I guess what I'm saying is he always made sure that we knew that, notwithstanding that he was working incredibly hard, building his practice, especially at a time when we didn't have the technology, or he didn't have the technology where he could work remotely, he came home, he was there for us. And then, as I learned as I grew older, he went back downtown to the office to work. And so what struck me as I started to build my own career is just recognizing that, it is a lot of hard work to build a practice, but being there for your family and being there for the people who are meaningful to you. So when I think about the ways that he kind of inspired my practice, it's really about keeping those priorities in order. Um, I have seen him in court. When I was in law school, he had a case in front of the Supreme Court, and I um, tagged along to go and watch. So I got to see him as an advocate. Um, I don't know how similar or different our styles are, but I wouldn't have worked closely enough with him to be able to take anything substantive from his actual legal expertise. He'll be happy to hear me say expertise, but really that influence was more in just um, making time for the things that matter outside of the practice of law.
All right. So now that you are a fully formed adult and a fully formed lawyer, you can't blame your dad anymore. You are you, and you refer to yourself on Twitter as allegedly human, likely a Slytherin.
Yeah.
So explain that.
Well,
That's not your dad.
no, it's not. Okay, so the allegedly human part is there's a couple things about the way that lawyers speak, which I always think is kind of funny. And one of them is this allegedly word that we seem to want to insert into every conversation in court, obviously. Um, well, it's quite obvious, that if you're quoting something from the other side's statement of claim, I don't think you really need to say allegedly after every sentence. But we do it. It's the same thing where if you're pleading in a statement of defense and you're doing an alternative pleading and you say, to the extent that there was a breach of the standard care bracket, which is denied. Like, I've already denied it for the past 15 paragraphs, but I'm still going to say which is denied to avoid somebody saying, well, he didn't deny it when he pled in the alternative, and therefore it must be an admission. So anyway, a long answer to the question, why does it say allegedly human? Because there's some things that, I'm pretty sure I am human and not AI, although we could have that conversation. But we say it anyway. In terms of the Slytherin part, I think that there's and first, let's take the Muggle killing part off the table. That's not what I'm about. Um, but there's a lot of practice as a lawyer, which I think ties into some Slytherin characteristics. So I think to succeed in this profession, especially in the commercial litigation world where we're in, you have to have ambition. You have to be out there deliberately trying to obtain clients and make connections and do those things. And I think that kind of ambition is perhaps Slytherin. The other part, I think, is that our job involves nonstop persuasion. And it starts from the time where you're introduced to a client. And you've got to persuade and make the client comfortable with the fact that you are with them and on their side, and their dispute is as important to you as it is to them. And you build that relationship through persuasion. Then you turn to the lawyer on the other side, and you've got to be persuasive in a way that leads the other lawyer to understand that you want to work collaboratively with them to the extent that there's a possibility to obtain some kind of a resolution before you go all the way to a trial, and you have to build that relationship. And that involves an element of persuasion and perhaps a little bit of a Slytherin kind of characteristic. And guess what? If all that doesn't work out, then you've got to build a relationship with the court, and you've got to be persuasive to a judge and build that rapport and have credibility, and keep all those relationships in line and intact, so that you can achieve something which is meaningful for the first person who we talked about in this chain. And that always struck me as a little bit Slytherin. I don't want to think of it as being two-faced, because I think your your best self as an advocate when you're not two-faced, and you're being authentic to who you are. But there's a recognition, I think, that you've got to be able to build these relationships and find the parts of your personality, the other side's personality, to really be able to advocate and achieve something meaningful throughout the entire process. And that's a really long answer to the question of why that's part of my Twitter bio, excuse me. And perhaps that's why Twitter, I don't know if it's still limited to 140 characters, but perhaps it's better off, so then you don't get all of that and you just get the potentially Slytherin or whatever it says on the Twitter bio.
I love long answers. This show is all about long answers. You talked when you gave me this long answer. I want to stick around a little bit and talk about this. You essentially talked about growth as a lawyer. You talked about progress as a lawyer, and I'll take the risk of sharing what you told me earlier when we talked before the show, and quote this great metaphor that you used. I really loved it, and I thought about it a few times after our conversation. You compared a litigator's career to unlocking next levels in a video game. And I'm sorry if you told it to me in confidence. I just breached it. I apologize, but this metaphor is so good, it was worth it. And I think I really want to share it with our audience. This really appeals to me, and I want to jump back to your story of the word allegedly, and how litigators constantly try to hedge their bets and procedure. There is also this saying that lawyers should be paranoid. My theory, and please share your thoughts about it, is that lawyers hedge their bets because they are brought up paranoid by law school, by law firms, but they're paranoid. They should be paranoid perhaps in the first stage of their career. But isn't it true that truly successful lawyers, truly effective litigators, truly powerful litigators, they have to stop being paranoid to that extent? Because to do what you just said, to cast a wider net and to see a bigger picture, to understand you don't need to use allegedly so much, to use your example. You have to be less paranoid, not more paranoid. And to experiment, which is, I think, a prerequisite for creativity and success as a truly powerful litigator. To experiment, you have to be less paranoid. So do you have to get rid of some paranoia to go to the next level in the video game? What do you think about this?
It's a really good question, and even in your question, there's a lot that kind of was resonating in my brain in terms of how to answer it. I think my starting point, though, is as a litigator, I don't think you can you can move to the next level as it is until you've seen a number of files all the way through, until you've done a trial, until you've done an appeal. It's really hard to understand what a discovery transcript matters for, or how does it matter when you don't answer that undertaking and someone's at trial saying, well, you didn't answer that undertaking, now you got an adverse inference against you. So I think you need kind of that whole toolkit unlocked before you can start to think about, okay, if the end process is going to be a trial decision, what are those things that actually matter along the way? But to your question about, do you become kind of a better litigator when you're not as paranoid, to use your word, about making mistakes? I think the answer to that is yes. And I think it all comes down to a question of what's really effective advocacy. I would love to do a statement of defense one day, which is just, one paragraph and just says, no, this is not what happened. Just something really concise and direct, which of course complies with the rules of pleadings, but says in one paragraph or one page everything that would otherwise be put into um, 30 pages. And I probably won't. But I think part of moving away from the fear of making mistakes is recognizing, what do you actually need to do to succeed? And by that I mean succeed as counsel. And moving backwards then from, how do I get there in a way that makes sense to me, makes sense to the court, makes sense to the client? And I think that's kind of what building your practice and your style of advocacy is all about. It's finding those things which make you more effective as an advocate without the fear of, am I going to do this wrong, or have I missed something?
Can you talk a little bit about a few examples from your practice, a few examples of experiments or novel things that you tried and that worked or that didn't work? Anything that comes to mind?
Well, I think you probably tend to remember the things that didn't work far more often than you remember the things that actually did work. I have a very clear recollection of the first time I ever cross-examined an expert witness. It was in the course of an inquest, and coroner's counsel said to me before I went up to cross-examine, I think I was an articling student, and the coroner's counsel said, "Are you going to cross-examine this expert?" And I said, "I think so." And the coroner's counsel said, "Well, just be careful. All the other lawyers have gotten quite burned by doing so." And I thought, I'm an articling student. I know what I'm doing. I'm going to take a shot at this. And I scripted my questions very carefully. I asked my first question, I got a great admission. I thought, this is good. Second question, even better. And I thought, I'm going to try something a little different. And just watched everything that I built through two really good questions um, disintegrate.
Burn
So
to ashes. Yeah.
exactly. So the lesson, of course, learned from there is one question less, especially with experts, is the way to go. But in terms of trying something different that worked, the only other thing that I can that kind of comes to mind is before the province introduced anti-SLAPP legislation. So legislation designed at limiting or eliminating litigation aimed at uh, limiting public participation. I was retained for a number of individuals who were sued by a mayor in the weeks leading up to an election. And at the end of that case, on which my client succeeded, I obtained an elevated cost award, just under kind of the regular Rule 57 cost regime, and convincing the court that the litigation was effectively a strategic litigation against public participation,
Mhm.
even in the absence of that legislation having yet come to fruition. Now, to be fair, I believe it was before the legislature at that time. Um, but, you know, that legislation did not exist. And so bringing that forward to the court and saying, you still have the tools to do this, notwithstanding that the legislation isn't yet there, uh, was, something I think back in terms of trying to find a way to achieve something for a client without a direct path to so doing. And I don't want to say working around the edges to accomplish it, but uh, being a little bit creative in using the tools that were available at the time.
Can you talk a little bit about the life of a file on Jordan Goldblatt's desk? Let's start with the source of the file. Let's start where the file comes from, first of all, and then let's talk about different stages in the life of that file on your desk.
So I have a few institutional clients from whom I get regular work. I get referrals from other lawyers throughout the city, and then there are people who seem to contact me because of other work that I've done. So I'm very fortunate to feel like I have a number of different sources of work that can bring interesting files to my desk at any number of or any number of ways. Um, I feel like most of the work that I do, or more of it, is on the defense side. Um, so typically, when a file comes in, my first thought is 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 there a way that I can quickly get rid of this case on behalf of a client by way of bringing some kind of a preliminary motion to get rid of it? And you know, with the amount of time it takes for litigation to wind its way through the courts, if there's some kind of way to quickly bring resolution to the file, and perhaps I was thinking more in terms of a motion to strike, but equally, if there's a resolution on the table quickly that makes sense for everybody, then that's usually the first place where my brain goes. From there, what I'll probably try and do, or as part of it, is try to find one of the really great people that I get to work with to assist me in the file, and then it's the things that all of us do as litigators, um, figuring out what the pleading is going to look like, figuring out what documents are important, and building a theory of the case as early as possible, and sharing that theory of the case with the client. I really think it's important to make sure the client knows what is happening at all times. You never get in trouble from a client for over reporting. You do for under reporting. And I think our job as lawyers is really making sure our clients understand what the range of outcomes are at any different stage of a case. So building a plan, sharing that plan with the clients, and then of course as you go through a case, um, revising that plan as new information comes to your attention.
What's your trial playbook? So let's say you now expect the case to go to trial. What happens with you, with your team? What do you do?
So I like to start from step one and revisit everything as much as possible from the beginning, and that means pulling out the statement of claim and pulling out the defenses and the request for particulars and the request to inspect, and really trying to piece the case back together in my mind and figuring out what's important, because I feel like too often when you get to the precipice of trial, the issues that you think are at the forefront of your mind may not be the ones that matter and have mattered, and recognizing that you're going to be giving this case to a judge who has no familiarity with it whatsoever. And so trying to put yourself back into a bit of a first position as to where did we start from, I think is really helpful to trying to figure out, okay, where is it that we want to go and where do we need to go. um, I I think it's always very interesting to look back and see how a case was pled, and can the plaintiff get to where they want to go based on what's been pled? Can you stop them as a defendant with the way that it's been pled? And is the evidence there that you need to either get to the end result or effectively stop the other side? So I really try and put myself back into kind of a first position mindset, um, even though you're looking at the end result being a trial.
I want to talk a little bit about pleadings. Ostensibly, the rules make it easy to amend pleadings. Practically, it's hard to amend pleadings, especially now when the dates in Toronto for associate judges' motions are more than a year away. And especially for plaintiffs, amending pleadings or sometimes or often raises the specter of trying to plead a new cause of action by amending the claim, which would create an irreparable prejudice to the defendant. So do you think we should make it easier to amend pleadings, especially knowing that the case doesn't really have the case gets really a second life before trial, on the precipice of trial, like you said.
Yeah.
You just said that you go back to the pleadings, you start from scratch. So it's really a second life. Should we really make it easy to just start afresh before trial and not maybe plead a completely different set of facts, but make it easier to amend pleadings? What do you think?
So my general view on the rules is everything should be as easy as possible. And that includes pleadings. I think any possible opportunity to avoid motions at all should be taken. And so to answer your question directly, should pleading amendments be easier throughout the course of the litigation? Absolutely. Because at the end of the day, you're still going to end up in front of a trial judge. So imagine a situation where at least the document world is not going to change. And typically, if we're dealing with, two parties who have complied with their obligations to produce any document with a semblance of relevancy, you're not expanding the universe of the productions by expanding the pleadings. You're changing the framework within which the legal issues are perhaps going to be analyzed. So, you know, uh, who cares? And I mean that kind of facetiously in terms of, does the legal framework have to change, or should it be contested? Who cares? Just do it. Do it. Change everything, not change everything, obviously, but if there's going to be amendments to a pleading required, it should be very easy to be done. And then let's go forward. Um, the more time that is spent on litigation that does not actually matter to the dispute, anything that can be done to take out those interim steps, I think should be done. And moreover, with the strain on judicial resources, I think it increasingly has to be done. So that would be my view of what should happen when parties want to amend.
Right, and that may probably increase the likelihood of trials. By reducing the obstacles to trials, we increase the likelihood of trials, we increase the frequency of trials, and lawyers get to do more trials. So I'm looking at Jeff Adair's bio, and one of the things in his bio is that he has tried to verdict or argued on appeal as many or more judge alone or judge and jury cases that any other lawyer in the province of Ontario. I interviewed Joe Groya a couple of weeks ago. So he had this huge case in the late 90s that caused a string of other cases. Everybody should watch that interview to find out exactly what I'm talking about. But by the end of 90s, he already tried more than 70 Superior Court trials. Imagine how many Superior Court trials he has tried by now. So I interviewed Earl Cherniak. I'm not even going to tell you how many Superior Court trials Earl Cherniak tried, or really any lawyer of his seniority at Learners. They started that firm started by basically trying every case. And today, my claim to fame, recently on Twitter, I was talking about myself, and I said, "Oh, I actually first chaired a trial in the Superior Court. This is my claim to fame. I first chaired in the Court of Appeal." I don't think I will ever be able to say that I tried as many cases as any other lawyer in Ontario, for example. So what do you think about this situation? You also said that you try to bring a motion in almost every case to end it early because I assume trials are so expensive and unpredictable. Is this status quo acceptable? Should we have more trials? Should we actually have fewer trials? What do you think about this?
I think there's no question that the number of trials is significantly less, but I don't know if that matters from an access to justice perspective. I think as a lawyer, my preference is always going to be to do a trial than a motion, but I don't think that's, frankly, I don't want to say ever in my client's interest, but I don't think it's usually in my client's interest because of the cost and time involved in a trial. One of the things that, in the course of my uh, career that I've been most frustrated with is when I started practice, summary judgment used to be easier to obtain. And by that, I don't mean winning a summary judgment motion. I mean booking a summary judgment motion. And the Supreme Court then comes out with Brainiac, which is supposed to make summary judgment an alternate form of dispute resolution and easier to get. And somehow we've gotten to the converse where summary judgment is more difficult. Partial summary judgment doesn't exist anymore in this province in almost all cases, with the result being that we seem now more locked into trials that don't happen than we ever have been. From a practice perspective, trials are the most important things for a lawyer to do to develop their practice, because that is what everything is moving towards. That's how you know if the evidence you've elicited or understood along the way matters or not. And the lack of opportunities for lawyers to do trials, I think, probably creates situations where when you get one, it's a different, it's more difficult for the lawyer. The more you do, the easier they are. But do I think that there should be more trials? No, but that doesn't mean that I don't want to do more trials.
Jordan, you've practiced law only at boutiques, correct?
Yes, that's right. Yeah.
Do you have a feeling that the number of litigation boutiques has been exploding lately?
I don't know, and I say that from having started my firm at a boutique. I feel like I've always been more aware of the existence of really good boutique firms, which kind of, have been there at least since I started to practice law. So has there been is there been an explosion of boutique firms? I don't know whether quantitatively there is. I certainly do feel that a lot of the really good litigation work is routinely coming through boutiques. And I don't know if that's what I would have said at the outset of when I started to practice law.
I'm curious about the advantages of boutiques over solo litigators. At the end of the day, when we talk about elite litigators, we talk about names of people. When we don't talk about I don't think we really talk about law firms. I mean, there are elite law firms, of course. I would consider your law firm an elite law firm, take it as a compliment. There are other law firms such as Lansner's where you grew up, right? And there are other litigation boutiques that no one has any doubt are of high caliber. But at the end of the day, do you think clients go to individual lawyers rather than law firms? Because I also am aware of lawyers leaving boutiques and taking clients with them, and clients often following them. So can you talk about the distinction between individual lawyers and boutiques? And also, can you talk about the advantages of boutiques over solo litigators that never work in boutiques? Do solo litigators have no chance of getting work from institutional clients, for example, because boutiques provide infrastructure that institutional clients demand? Can you talk about this whole matrix for me, please?
So I think the best way I could answer that question is that I do believe that individual clients who are outside of a full service firm will search out the litigator or lawyer who is best responsive to the dispute that they have. And whether that is a boutique or a lawyer practicing in a boutique or a lawyer practicing individually, I don't think that dichotomy necessarily matters. I think larger institutions who have full service firms are more likely to say to somebody at the firm, here's a dispute, who's the best person within the firm to do it? And in many cases won't know that litigator in advance of that file coming to that litigator. But certainly within the boutique solo practice, solo practice, solo professional world, I do think individual clients are more likely to reach out to an individual and a person that they know. As between a sole practitioner, I said the word practitioner right that time, and a boutique, I think the only real significant difference is I don't think of our firm as being a bunch of sole practitioners, but we all do have our own practices. We all do have our own clients. I think what a boutique has, which is a little bit of a benefit over a sole practitioner, is the ability to bring other people into a file and provide a little bit more depth of support depending on what the issue is. If I was just practicing by myself, number one, I couldn't take on the volume of work that I have. And number two, I wouldn't have access to the really good legal minds, which sometimes have been working on one of my colleagues' case and can bring their information from that other case into the work that I'm doing. So I kind of tend to think of it as, two-dimensional, three-dimensional a little bit. And so at least within a boutique structure, when you have other people who you're regularly interacting with, I think it does give a little bit more depth to the practice and to the work on the file that ultimately assists the client.
You're the managing partner. I'm sure you're involved in hiring decisions. Correct me if I'm wrong. I'm pretty.
I am.
So, and you just talked about bringing other lawyers into files. I assume you talk about probably mostly associates or more junior lawyers. Can you talk about how you hire lawyers at Adair Goldblatt Bieber LLP?
So in the 5 years since we've started this firm, we have almost never been at a point where we've felt that we've had the right staffing matrix. I think we're around 21 lawyers now, and we've always felt that there's not enough, notwithstanding that when we started at 9 lawyers and we hired our 10th, I think I had a small heart attack thinking about, okay, are we actually going to be able to support another person? But we've always kind of continually been on the lookout for individuals who we think could help and benefit the firm. People have come to us all kinds of different ways. We make a deliberate attempt to try and go to the Ontario Court of Appeal every year and do some recruiting there. But other than that, we've had people who have been introduced to us organically from friends of the firm. We've had people reach out to us, younger lawyers who've said, look, I see the stuff that you're doing. I've heard about the environment and I'd be interested in joining. Can we have a discussion? So we've been very open to being contacted through any number of different channels and trying to figure out what our needs are and what allows us to kind of advance as a firm while trying to keep a culture at the firm which we think is reflective of the way that we want to practice, being somewhere which is inclusive and collaborative and allows people to be themselves in the work that they do.
What do you look for in let's say, young junior lawyer?
The thing that we really want is somebody who, first of all, you have to want to do civil litigation. And I know that's kind of a strange thing to say, but when we meet with somebody and they say, well, I think I might be interested in doing civil litigation. I had a friend who said civil litigation would be good. We don't have we're not going to hire somebody, to be honest, who thinks they want to do civil litigation. You have to know that you want to do this in order to be here. we're not at a point where we're going to expend resources in somebody who thinks they might want to try this. So um, that's kind of one of the things I tend to think about. But beyond that, we're looking for people who are interested in the law, and that can come across in any number of ways. You can be interested in it from kind of a jurisprudential perspective. You can be interested in it from an advocacy perspective. You can be interested in from a social justice perspective. But somebody who is thoughtful and wants to be involved in the aspects of this profession that are meaningful is someone who, from a firm perspective, we want to be having a discussion.
I am looking at your bio on your firm's website, and I see that one of your clients, institutional clients, is Law Pro.
Yes.
And can you tell me how big that client is? Is it occasional, or is it a regular stream of work?
It is a fairly regular stream of work. The number of times lawyers are sued against is not an insignificant number. There's a bunch of firms, of course, who are preferred counsel throughout the province. I feel fortunate to be doing the Law Pro work. I love acting for lawyers. I love the responsibility of saying to a colleague, let me help you with an issue. You know, I think it's a privilege to be able to work with another lawyer who has found themselves named as a defendant in a lawsuit. And I think it's really helpful in terms of the way that I practice on my own files to see where there are circumstances where a client has come back and said to another lawyer at the end of their claim, now I'm going to name you as a defendant in the lawsuit. I think it's very helpful in terms of my own practice, and the way that I practice it, and frankly, also the way that I deal with other members of this community, recognizing that they might be an insured on a file at some point in the future.
Is there an type of cases, Law Pro cases, that you usually do? Is there an area of specialization, or do you take all kinds of cases from Law Pro?
I have a really broad Law Pro practice. I've done cases in the insolvency area. I've done a bunch of just standard negligence cases. Done a bunch of real estate cases for Law Pro. The circumstances where a lawyer can be sued by a dissatisfied client are not closed, as they say.
Is there a pattern, a recurring pattern of mistake that you see in some in your work that lawyers make? Can you share some observations, some wisdom about most common mistakes that you have to defend, or allegations of mistake, or maybe mistakes that lead to allegations? Maybe they still made a mistake.
So the biggest place where claims seem to arise is in the stage of clients understanding what it is that the lawyer is doing. So the lawyer thinks the lawyer thinks they have instruction to do X on a file, whether it's bring a motion or withdraw an admission or any of those things. And then something happens and the client says, well, I didn't instruct you to do that. And that's a situation where invariably the lawyer says, well, I had 55 phone calls and I spoke with the client and they understood what we were doing. And now I can't understand why they're suing me, saying they didn't. And I say to them, where is your file note? Where is your email? Where is something where we can say to the court, this is something where the client understood what they were doing and gave instruction. And so that's the most frequent thing, where in the course of a file, if the lawyer had taken literally 3 to 5 minutes and sent the email saying, I confirm that we have discussed X and Y and you have instructed me to do that, then even though you can obviously still get sued, the nature of the defense changes considerably. So that's kind of the first piece. The other thing I would say is lawyers need to remember that our job is to give advice, and the client's job is to give instruction. And always keeping clear in your own mind that it's our we're just retained to give our thoughts and insights into what it is that we think should happen, or excuse me, and it's the client who gives the instruction. So recognizing that it's not the lawyer who gets to make the call, it's the client. And so kind of keeping that perspective throughout the life of a file is one way that I consistently think of could avoid a number of claims, at least in the Law Pro cases that I've seen.
Jordan, you're a sports fan, you're a Jays fan, and I see that again from your bio page on your website. I see that you did a lot of work for sports teams, sports organizations in the area of sports law. Can you talk about that a little?
Yeah, so to start my answer, you properly characterized my love of sport. I can tell you early in my career, I did a retainer for Tennis Canada, where I explicitly wrote into the retainer agreement, I get to tell people I was doing work for Tennis Canada. Because I thought, like, this is really cool. I love tennis. And in fact, one of the things that I insisted we do is meet at the National Tennis Center, and I walked on the court at what is now, I think it's at York University. I can't remember what it's called. I don't want to get the corporate name if who actually owns that arena wrong, but standing on that court was one of the highlights of at least my sport practice. But the sport world presents really unique challenges for the organizations themselves and counsel who get involved in those disputes. It's a really difficult space to navigate between the obligations that are owed from an athlete to a national sports organization to a provincial sports organization. Where do the coaches fit into this? For many of the organizations, you've got referees who have a seat at the table for some of the national sports organizations. You have grassroots level organizations who sometimes have some membership rights. And so it's a really interesting interplay between all these various participants, and something that is really done for most of the people involved as a real passion, especially where in this country there are very few individuals who are going to be making the kind of cash that you see from professional athletes at in kind of the baseball, basketball, hockey, in those sports. And I haven't even talked about the doping cases, which I had the opportunity to do. So they're really interesting cases with clients who care. The athletes are coming back to the doping cases. If someone is looking at a 4-year suspension in the middle of their career, that 4 years is probably going to take them to the end of their career. So they're good cases which have high stakes for the people who are involved. And I think it's really important for the parties involved to get good counsel to help them through those disputes.
Jordan, it's been a true pleasure. Thank you so much. I really enjoyed it.
Me too. This was great. It was a lot of fun.